my take on how to think like a lawyer, or in my case, how to think like a law student. In my opinion, thinking like a law student or lawyer means three things. One, to think critically. Two, to see the other side. And three, to reason through analogy. Count one, to think critically. What do we mean when we say critical thinking? Generally, it means to think rationally and apply rigorous analysis to the facts or assumptions in order to arrive at a judgment. It means to question assumed facts or doctrines and test them against research, other views, or logic in order to arrive at an unbiased conclusion. It means being open to the idea that you can be wrong or that you fail to consider all the evidence. Example A. When you have the facts on your side, argue the facts. When you have the law on your side, argue the law. When you have neither, just argue. This is a funny but accurate description of what it means to study the law. While I'm still in law school, I have plenty of experience working with and against attorneys. This expression, however, was told to me many years ago by a friend who went to a top law school. During a mock trial class, we were separated into two groups, the plaintiff and the defendant. We were given the same fact pattern and the same cases to review, but each side had to advocate for their client. You would think this would be hard to do, right? But no. The side that wanted the case to go to trial argued that the facts were in dispute. The other side that wanted the judge to decide the case right there and then argued that the facts were not in dispute and they had controlling law in their favor. But, as the saying goes, if neither the facts or the law are on your side, just argue. Example B. Some of you may recall President Clinton's impeachment in 1998, where he was impeached by the House on the grounds of perjury and obstruction of justice. When asked about his relationship to Monica Lewinsky, he reported, "There's nothing going on between us." But, according to the Star report, he said, "It depends on what the meaning of the word is. If is means is and never has been, that is one thing. If it means there is none, that was a completely true statement. Now, if someone had asked me on that day, are you having any kind of relations with Miss Lewinsky? That is, asked me a question in the present tense, I would have said no. And it would have been completely true." Now, Clinton, being a good lawyer, understood that by questioning the definition of the word is and by analyzing the manner in which the question was posed, he could explain away his earlier statement. Count two, seeing the other side. Going back to my mock trial example, in order to prepare for our oral arguments, we had to anticipate what the other side was going to say. That meant seeing the case from their point of view and evaluating their best and worst arguments. Then preparing a response to those claims or arguments, either by finding holes in their argument or by explaining how our position was different or more to the point. Through this process, you're able to build a stronger case and be better prepared. Count three, analogical thinking. Lastly, we have reasoning by analogy. And I want to draw a distinction here. Lawyers are not scientists or philosophers or engineers. Generally speaking, there are four kinds of reasoning. Those are deductive, inductive, causal, and analogical. Deductive is reasoning from the general to the specific, what is more to be considered philosophy. But obviously, that's not what lawyers do. Inductive is reasoning from personal experience or by doing some type of research. Causal reasoning is more in the field of math or a hard science, where you study the cause and effect of things and try to draw connections between the two objects. But lawyers use analogical reasoning in their legal briefs and oral arguments. Reason by analogy means comparing two things and highlighting aspects in which they are similar or dissimilar. For example, you may write or argue that in the Duncan case, the court looked at how to incorporate the Due Process Clause with the Sixth Amendment. With that, you then apply the rule to the new set of facts to support your claim. Generally, you look for examples that have binding authority to reinforce your argument.